In this video, I'm going to talk about Chapter 7. I am not going to make a video on Chapter 11 for two reasons. Number one, Chapter 11 just does not lend itself well to a 5-minute video. There's a lot of moving parts there. But more importantly, I have been representing people and representing businesses in financial distress for over 30 years. I have made it my mission to try to get these people and these businesses through their problems in a cost-effective way. Chapter 11 is almost never cost-effective for a small business. And so I see Chapter 11, quite frankly, as a last resort, and frankly, a rather desperate last resort. Chapter 7 actually opens up interesting avenues, even for a business that wants to stay in business. In the Chapter 7 context, we do have to consider kind of three different scenarios. One is the sole proprietorship. The other is the corporation or LLC, where the sole proprietor has personally guaranteed the debt or a significant amount of the debt. And the third, in which you have a corporation or LLC and the owner has not guaranteed any of the debt, or at least not enough of the debt to matter. In the case of a sole proprietor, it's actually relatively easy. You file Chapter 7, all your debt goes away. Now, you may have a fair amount of, and you can just simply start over. The whole point of Chapter 7 is to wipe the slate clean. So say you're a contractor, or even a lawyer, and you file Chapter 7, you can pretty much, you might want to change your DBA, but you can pretty much start over more or less right away. Your old debt goes away. The trustee now owns the assets of your business, or the bank may be ready to take the assets of the business, but there are often ways to get those. In the case, well, let's take me. Imagine that I were to do this. I would imagine that my clients would immediately come right back to me in my new DBA, especially if I was honoring whatever payments had been made to the old me. I own my copy machine, I own my computers. They would now be property of the trustee, but the trustee doesn't want them. The only issue is, where am I getting the money from to buy them? Although trustees will usually even take payments on these sorts of things, not for years, but for maybe 6 months. But if I can demonstrate, where I'm getting the money, or if I had a little bit of cash that I was able to carry through the bankruptcy, or, I borrowed it from my mother or my best friend or my rich uncle, or, whatever, that would all work. And you could reestablish the business and reestablish it fairly quickly. The same is true when you have a corporation under proprietorship. The owner has guaranteed a fair amount of the debt. The only difference there is that you have to take both into bankruptcy, both the old corporation and the owner of the corporation. And that's just to keep the new corporation that you form, almost right away, from being what's called an alter ego of the old corporation. That's something that you do have to avoid. I've had some situations where that was really a big issue, where there were creditors who were lined up waiting to say, wait a second, the new corporation is the same as the old, and therefore we're a creditor of it. But this would extinguish all of that. When you have a corporation or an LLC in which the owner is really not on the hook for the debt, that raises a whole host of issues. Chapter 7 may work. Closing the doors and walk away may work. An orderly winding down of the corporation outside of bankruptcy may be the best path. But these options all become available, and we're available to help figure out what is the correct path. I will next, after this, I think I'll start discussing situations for businesses that are probably ready to throw in the towel and close. So until then, be safe, be strong.